we know what a dismal failure the existing district attorney had been, and I'm not even involved in the court system itself, but I read the papers, and I can see that there have been a lot of issues that our present district attorney has not been able to handle, and it was my understanding that she had so much experience and had been there for such a long time that she was ready to step into that position. Well, for whatever reason, 4 years later, she's not running. And
if you are elected, how do you plan to break the cycle of misconduct in the office?
I don't think there's a cycle of misconduct in the office. No
You don't believe it exists?
A cycle of it? No, sir. No. Thank you.
thank you, Paul.
I have a question, but I want to direct it to both you and Paul. A year ago, there was an unfortunate situation in the DA's office with Mary Kellett. It made the newspapers. How would you have handled that as DA?
We need a little background. Just what was it about?
Well, there was information withheld at a man did time.
Did everybody catch that? There was, say it again, Janice.
There was information withheld from the courts, and a man did some time for it.
Mary Kellett was an assistant district attorney.
So I just want to know, as DA, how would, what would you have done? How would you have handled it?
You stand.
A couple of teaching moments, I call it, with my kids to make sure. The district attorney's office does not get cases from the public. We get them only from law enforcement. You can't call and say, here's a report, I want somebody prosecuted. We would refer you to law enforcement in whatever jurisdiction. What happened in this case, and if you, it is in the paper, you can find it in the Bangor Daily News, click down, the gentleman's name is Vladek Filler. He is associated with a number of groups that think men have been mistreated over history, that the women have masterminded the criminal justice system and the divorce system, and Mary Kellett is just another one of those women that has taken away all the rights of poor men. So look at the source of his complaint. I prosecuted the case the second time around. Ms. Kellett prosecuted him. There were two pieces of evidence that were at issue. The first was some written statements in an unrelated case to the Ellsworth PD, and the second item was a recording from a Washington County deputy. I don't remember whether it was a 911 or from the cruiser, but there was a recording made in the normal course of law enforcement. And Ms. Kellett had asked those two agencies for that material. The court had ordered her to provide it to the defendant. She requested it from those two agencies. The agencies did not provide it to our office, so we did not give it to him because we never had it. After his first trial, he got his hands on that stuff. It did exist, and he went to the court and said, wait a minute, I didn't have this. And the court said, Ms. Kellett, you should have given it to him. And she said, I didn't have it. I asked for it, and they didn't give it to me. How can I give what I don't have? And he filed a bar complaint and went through, and the court found out that the Board of Bar Overseers determined that she did not do enough due diligence in trying to get that it wasn't enough to say, hey Scott, you got anything? No, okay, thanks. There had to be a more formal process, and she failed to follow it, and she was held responsible for that. It didn't stop him. It didn't mean that he got away with abusing his wife because there was a mistake in the evidence. He got a second trial where he was convicted again of assaulting his wife and sentenced to 20 days in jail. Those two pieces of evidence that were so important denied him his fundamental trial the first time were never used in the second trial. They didn't have anything to do with the second trial. Mr. Filler has now filed what we call a post-conviction review, a PCR, where he's saying even that conviction should now be thrown out because his defense attorneys weren't competent. So one thing we can be clear of is that it wasn't Mr. Filler's fault. It was his wife's fault, and then it was the prosecution's fault, and now it is the defense attorney's fault that he had to do time for assaulting his wife. So what would I do? What will happen? I've been on the Board of Overseers for 8 years. I've sat on those committees. I've done those decisions. We are in the process of a fundamental sea change of how that discovery material is handled. If you pick up the paper, you can see countrywide this is an issue and a problem. They just sent a judge in Texas to jail because when he was a prosecutor, he had stuff in his file that he didn't give, that he didn't think he needed to. Now, 25 years later, they're saying he had to, and he's been convicted of that and sent to jail as a judge when he was a prosecutor. Doesn't take too long ago, 6, 7 years ago, Duke Lacrosse, that case down in North Carolina, with a prosecutor running for office, fabricated something to try to get culture of the race vote, and he was disbarred and prosecuted himself. Okay, so it is a sea change in the way that is happening. All across the country, we were changing those policies. Law enforcement isn't real happy with this because instead of a phone call to Scott saying, hey, do you have that video, do you have that report, we're now demanding everything be in writing, we're demanding everything be so that we can tell the defense attorneys, yes, this exists, no, this doesn't exist. It is one of those moments when the world is changing. The bar has addressed Ms. Kellett's behavior and has imposed sanctions and imposed consequences on her for that behavior. I don't know that that was the only possible outcome in the understanding of the way it happened, but that's the way it happened, and she's been held accountable for that. I prosecuted the case when she was removed, and everything went fine, and as far as I know, he hasn't complained about me yet. So that's how I would handle it. You fix your mistakes. We're human, we make them, you move forward, and try to put systems in place to avoid it.
But she admitted her mistakes.
She did, yes.
Yes.
Can I just clarify a couple of things there? Ms. Kellett's, the failure to turn over the information wasn't the only issue. Ms. Kellett, in her closing argument, commented on the fact that the defense didn't present any of the evidence that she never gave them, which is one of the issues. She said, where's the evidence to the jury in this case? And it was the evidence that she never gave them. So that was what the Board of Bar Overseers had a problem with. Mr. Filler was also charged with gross sexual assault in that case, which he was not convicted of. So to say that he was convicted of assault, yes, he was convicted of misdemeanor assault in certain 20 days, but in the meantime, he had been charged with gross sexual assault and served quite a bit of time in the county jail waiting for his court date to come. Those charges were not. He was found not guilty of those charges. So to say that Ms. Kellett's conduct didn't have any effect on the case is, I think, even if it didn't have an effect on the case, it had an effect on the justice system and the way the public perceives the justice system and the way the public perceives the district attorney's office. It just shouldn't have happened.
Okay, well, that was a good little thing.
Yes, sir.
If you are elected, how do you plan to break the cycle of misconduct in the office?
I don't think there's a cycle of misconduct in the office. There's no
You don't believe it exists?
A cycle of it? No, sir. No. Thank you.
Thank you, Paul.